Good afternoon and welcome to the third part of the POPI webinar series. The NSG has partnered with the Information Regulator of South Africa to deliver webinars on the POPI Act. This particular webinar is to provide guidance to responsible parties on how to conduct a personal information impact assessment, which is a process to assess compliance with the 8 conditions for lawful processing of personal information, identifying risks and proposing mitigating measures. Furthermore, guidance on how to develop and implement a compliance framework will be presented. A compliance framework will support the fundamentals of an effective privacy management program for responsible parties. At the end of this webinar, we hope that you will be able to design a POPI compliance framework, as well as be able to conduct a personal information impact assessment. I'd like to now hand over to the Professor Busani Mlaweni, our principal of the NSG, to provide the opening and welcome. Professor Mlaweni. So I think your camera is frozen. We apologize for the technical issue. We're just trying to get our principal back, and we are just beg your indulgence for a few minutes.
Hello, can you hear me now? I'm back. Hello, Allison, can you hear me?
Yes, we can hear you. Thank you.
Great stuff. Okay, no, so I was saying thanks to you and Louise who've been making this arrangement. I must also then thank the colleagues from the information regulator. This is much appreciated, this partnership that we've had. This is a third iteration of this webinar. We don't take it for granted that you make yourselves at a very senior level available to engage public servants and talk about a very important piece of legislation that all of us have to comply with. The attitude at the National School of Government is that when we talk about building state capacity, we talk about the combination of factors. One, it's about having skilled public servants who master statecraft, so they know what to do as prescribed. If they have to issue permits, they're able to issue permits, and those are correct permits and they're issued on time. If they have to issue a birth certificate, they do it and it's done on time and correctly without spelling mistakes. If they have to give social grants, that they do so without humiliating young mothers and asking them why did they get pregnant in the first instance. They do what they have to do as prescribed by law, and that they do it with empathy and the kindness necessary. That way, when the public interact with us as public servants, they will say we are professional because we treated them empathetically, and they say we are professional because we delivered a service proficiently. When you talk about state capacity, we're also talking about people knowing, understanding the legislative environment, and knowing how to comply with the legislative environment. For example, POPI itself has got a lot of responsibilities that public servants need to be aware of, because if we violate those, I'm making an estimation here, colleagues, that the personal injury lawyers who were busy at Road Accident Fund at some point, and they moved from RAF into the Department of Health. My prediction is that those personal injury lawyers are now going to be all over the state using POPI violations, because these are low-hanging fruits for personal injury lawyers, that they will be suing government employees and government state departments for violations of POPI. It is essential, therefore, that working with the regulator and other stakeholders, that we are able to empower public servants to know how to navigate the intricacies of this. Oftentimes, when we were caught on the wrong side of the law, we blame an institution that is responsible for overseeing the implementation of that law. It is not you as an organization that wrote the law. It is a policy department that wrote the law. You are custodians of implementation of that law. It is important, therefore, that you have these engagements and as you have opened your doors to interact with public servants and so on, so they know that when they are challenged in the future by yourselves, it is not because you are on a witch hunt looking for people who are violating and you want to punish those people. Awareness is very critical on matters like this ones, and we appreciate that you are able to be here. And if there are public servants who have consistently been attending this, we hope that they are taking something away from it and sharing and telling other people about it. It's important that public servants were able to think creatively around how do we, if I'm a media liaison officer, I'm working in a department, I go to an imbizo with my political principal, we take pictures. You have to know how to navigate situations like those, because half the time it is not your intention to deliberately break the law, but by you understanding the law and the regulations, you improve your ability to navigate and manage those complex situations. Because tomorrow, a personal injury lawyer may say, you use this image, you never got permission for it, and so on. As Department of State, all of us are now working and carrying big data. This big data needs to be protected, it needs to be safeguarded, and we need to spend resources doing so, and well as building the capacity of people across the system to know how to manage big data, because it comes with a lot of responsibilities. So thank you once again for being here, all of you as attendees and the colleagues who have organized, and the colleagues from the regulator. Let's have a great conversation further. Thank you, Program Director.
Thank you very much, Principal, for that very warm introduction. Just some housekeeping. If you could please keep your mic off, and please keep your camera off. We're encouraging you to please use the Q&A function, which you will see at the bottom of your screen next to where it says participants. The icon next to where it says participants is a little Q&A with 2 speech bubbles. If you could please note your questions in there, the panelists will address your questions. I'd now like to introduce our next speaker, Ms. Allison Chili. Ms. Chili is an attorney specializing in transparency and accountability issues. She has litigated on transparency and whistleblowing issues in a number of high court matters, the Labour Court, the Constitutional Court, and Supreme Court of Appeal. She was formerly the director of the Open Democracy Advice Center. She's the coordinator of the Judges Matter Campaign, which is a project of the Democratic Governance and Rights Unit at the University of Cape Town. They have an extensive campaign on judicial appointments and conduct processes. Her publications include The Right to Know, The Right to Live, edited by Richard Calland and herself, and she contributes to the Daily Maverick. She works on issues surrounding gender-based violence and particularly the rollout of sexual offences courts with Rape Survivor Justice Campaign. Thank you very much, Ms. Chili. I'd now like to hand the floor to you.
Well, thank you very much, Prof, and thank you very much for the welcome, Prof. Aweni. As you've indicated, this is part 3 of a 3-part series, and I'm afraid that each part could have probably been 3 times as long. there's a lot to get through in this legislation. The regulator is the custodian of both POPI and PIA, PIA being the Promotion of Access to Information Act. The role of the regulator is not just to be a big stick and frighten everybody with consequences if POPI is and PIA are not respected, protected, promoted, and fulfilled, but also I think to encourage people to think about these rights to privacy and rights to access to information as really important developmental rights in a country which is plagued by poverty and inequality. We know that data is the new oil. People say that. What they really mean when they say that is that companies that do nothing but trade in data are very, very, very rich, and that we need to look after our data as a natural resource. And that's part of what the regulator is here to do. In our previous webinars, we've talked a lot about POPI. We're going to talk a lot about POPI in this webinar as well. We certainly hope to look ahead and perhaps do one on PIA, which is the other part of the regulator's mandate. The members of the regulator are appointed by the committee. They're then committee in Parliament. We're voted on by Parliament, and then we're appointed by the President. So I guess we feel responsible for making sure that the regulator really does its job. If I can say from our side, I'm sorry, let me just do that. If I can say from our side, we have a number of colleagues with us. From the Education and Communication Division, we have Mr. Dimba. Ms. Sondi is also with us. And then we have a number of other colleagues. I think the two that you're really going to see most of today is Ms. Farsha Sulal, who heads up the division that deals with policy and research. We're also going to have Ms. Ramasio, who will be addressing us as the second part of the presentation. And then also we have with us Mr. Ludidi, Mr. Morwenyone, and Ms. Shalembe, and Ms. Kampola. So without further ado, perhaps I can, I think, MC, hand over to Ms. Sulal and ask her to begin her presentation.
Thank you very much, Ms. Chili. I'm now going to introduce Ms. Varsha Sulal. Varsha Sulal is a privacy and tech attorney skilled in providing sound legal expertise across highly regulated public and private sector environments. Varsha started her career in private practice and then served with the public protector. She was thereafter appointed as Master of the High Court. She assumed the role of Chief Director Legal Services and headed the legal directorate with the Department of Employment and Labor, Workmen's Compensation, and the UIF. Varsha is currently the executive heading Legal Policy Research and Information Technology Analysis and the Deputy Information Officer with the Information Regulator of South Africa. She's a doctoral candidate in ICT law, privacy, and cybersecurity. She's also engaged with global internet governance programs and is passionate about development through ICTs. So thank you very much, Varsha, for giving us your time. I'd now like to hand the floor to you. Thank you.
Thank you very much, Prof. Thank you for the opportunity. I'm going to get right in to my presentation. All right, I seem to just, okay. There we go. I'm going to address you today on the POPI compliance framework and personal information impact assessment. And the purpose of this is that, there's a legislative mandate on information officers to ensure that they have a compliance framework in place and that they undertake a personal information impact assessment. And what does this actually mean? So in terms of Section 55(1)(a) of the Protection of Personal Information Act, an information officer is responsible for compliance by the body with the conditions for the lawful processing of personal information. And Regulation 4(1)(a) relating to POPI prescribes that an information officer must ensure that a compliance framework is developed, implemented, monitored, and maintained. And we need to unpack what this actually means. In terms of Regulation 4(1)(b), there's an additional process which prescribes that information officers must ensure that a personal information impact assessment is undertaken, and I'm going to call it PIA. An impact assessment is basically a process that is utilized to assess compliance with the 8 conditions for lawful processing of personal information. It will enable you to identify risks associated with the type of processing that you undertake and enable you to also identify and propose mitigation measures that would minimize or diminish the identified or anticipated risks. And an impact assessment should be conducted to ensure that adequate measures and standards are put in place in order to comply with the conditions of the lawful processing of personal information. To try and unpack what a POPI compliance framework actually is, accountability is a principle that all organizations across many disciplines need to abide by. And what the POPI compliance framework actually does is that when you look at the accountability condition, it's one of the conditions in POPI, and it also enables responsible parties to demonstrate compliance with the conditions of POPI. In addition to this, appropriate technical and organizational measures must be implemented to meet the requirements of accountability and to ensure that the processing of personal information is in accordance with POPI. And all of this can become a nebulous concept because which policies do you actually look at, and what exactly is a compliance framework intended to achieve? So a compliance framework will govern personal information, and it provides a framework which thereafter forms the structure that will give you a holistic overview of how an organization will create and manage its enterprise-wide information assets. And this would consist of your records, any type of personal information, and data that you hold as an organization, be it public or private. A compliance framework would include some of these functions when you are planning to prepare one. It would provide you with strategic thought leadership. It will assemble cross-functional support. It will enable you to develop a privacy framework, analyze legal requirements, and develop a compliance framework from this. You would also be able to develop privacy policies, processes, and internal controls which protect personal information. And these will be inclusive of your privacy matters that you would encounter in your day-to-day operational issues. The components of a POPI compliance framework, as I've stated earlier, the compliance framework will have to support the fundamentals of an effective privacy management program. The compliance framework also needs to comprise of different strategies, initiatives, policies, procedures, standards, and guidelines that would work collectively to achieve POPI compliance. And just as an overview, your compliance framework would cover matters like establishing a governance framework, which has to include appointing an information officer, ensuring that you have adequate risk assessment policies and procedures in your environment, ensuring that you have an internal policy on the protection of personal information. And this speaks to the privacy ecosystem that exists in your business environment. It would also include you undertaking a personal information impact assessment. As you will note, the personal information impact assessment, or PIA, it would actually form as a component of a compliance framework. It would speak to your records management policy and also ensure that you have implemented appropriate technical and organizational measures. And this would be inclusive of ensuring you have a breach management process. You would also have to develop an information security policy, include a policy on accessing information. So it's not just about protecting information, it's also about making sure that certain information is accessible in terms of POPI. And you would provide for review mechanisms, because your policy, your framework is not going to be stagnant. It's going to be one that would grow and be augmented as your business environment changes. And what I've done here is that I'm going to just look at two of these components of the proposed POPI compliance framework. When you need to establish a governance framework, these are the types of measures that you should include in your compliance framework. For instance, registering your information officer, designating or delegating a deputy information officer if required, and to ensure that the information officer does develop a compliance framework, conducting a personal information impact assessment to determine adequate technical and organizational measures are put in place, ensure that you have a PIA manual, ensure that internal measures are developed together with adequate systems that will enable you to process requests for information or access. You need to also ensure that you conduct internal awareness sessions on POPI, the regulations, codes of conduct, or information issued by the regulator. You would also need to ensure that an organizational structure in your business environment will clearly identify operational roles. Develop policies and procedures that would give effect to your governance structure, and ensure that there is a review process of all policies and procedures. Under records management, the types of activities that you and processes that you could adopt is to make sure that firstly you have a records management policy, and that should incorporate the following. Firstly, you need to identify what is a record, identify records that require additional protection. Classification of the information that you hold in your business environment is critical, because you need to identify the kind of risk that information will attract. And the only way you can do that is firstly to identify all records that you keep in your business environment. Ensure that you can identify your retention and disposal periods, because you should not be retaining information longer than it has served its purpose for. And you need to ensure that every type of information that you hold, there is a congruent disposal period attached to that information. So you would have to basically create an information register and classify your information, identify what it is, link it to the time period that you ought to be keeping this information, and likewise, what is the time period for you to dispose of that information. You need to identify where records will be stored, assign specific individuals to implement records management, your tools, and have an implementation plan for your records management policy. Staff need to be trained on information that has to be retained and that which should be disposed of. And the time periods for that need to be adhered to. Develop an electronic records and document management system. And this system ought to enable you to access the categories of information that you identify, Select your employees, segregate duties where possible, because if you do that, you'll be able to enhance the protection of personal information. It's very wise to make sure that in line with the segregation of duties, that all employees don't have access to all information. Should there be a breach of any type or compromise, then you would have to account for not having put into processes that would ensure enhanced protection of personal information. As I alluded to earlier, maintain a register of all employees and their corresponding access to information technology systems and records. And the reason for this is that it's linked with the segregation of duties. If you have a register of who has access to what information, you would be able to identify where a breach or compromise of that information occurred. And it's often in a public sector environment that it's not always possible to implement that kind of sectioning of access. But that is what you ought to be doing to safeguard personal information. And I think it's prudent to mention that the public sector, and I believe that most of the attendees today would probably be from the public sector, that the public sector holds the largest amount of personal information in the country. And the last thing you want to do is to compromise that information and compromise millions of citizens that rely on us to abide by the provisions of POPI. In addition to this, what you can do is, and what you ought to do, is make sure that you conduct an audit of all your contracts, your service level agreements, your operator agreements, information systems, and ensure that they are aligned with POPIA, because many of these would have been pre-POPIA, and you need to conduct this audit to ensure or ascertain whether or not they abide with the principles enshrined in POPIA. When you conduct an audit of all your processes, where you collect, disseminate, record, store, or destroy personal information, you'll easily be able to identify whether or not you have attained compliance. And I mean, this compliance framework, as I mentioned before, it's to ensure the protection of personal information. And this is why conducting an audit of all your processes where information is collected, disseminated, recorded, stored, or destroyed will assist you in attaining compliance. You should be assigning protection of personal information responsibilities and obligations to employees, and this should form part of their individual job descriptions to the extent of it being included in their performance agreements. The protection of personal information is serious business, and I really believe that if these roles and responsibilities and obligations are clarified at the outset, it will enable employees and supervisors to ensure there is compliance and being proactive about protecting personal information. Incorporate the protection of personal information mechanisms into how your risk assessments are conducted and reported. And I mean, it's something that has to be done from the inception of POPIA. You need to also incorporate the protection of personal information mechanisms when you process health and safety protocols. Develop a retention and disposal policy of information. Ensure that your staff, again, are trained on all your policies and procedures. Ensure that paperwork is disposed of securely through shedding. The adoption of strict controls as to who can access personal information is important, and blanket access, as mentioned before, should be avoided at all costs. Included under records management, you should have a disaster management and recovery plan, a business continuity policy, and identify how personal information and records will be backed up in your disaster management and recovery plan and your business continuity policy. Store your backups of electronic information and systems offsite and ensure that it's securely stored. There must be secure storage of personal information to prevent unauthorized access. And I think that means, on a very basic level, look at how personal information is stored. There are many environments within the public sector where files are easily accessible. They might be on your tables, in unlockable cupboards, and we need to be very mindful that personal information has to be protected from the most basic level. And in as much as the responsibility of ensuring there's a compliance framework that has to be implemented by the information officer, which in the public sector is your DG or your head of department. But records management and the protection of personal information is something that is going to cascade all the way right from your administrative clerk to your registry clerks, even your drivers. And I think that has to be thought of when you are outlining or when you're trying to identify who has access to information and what is the level of access to the information that they have. I'm also going to cover the development of an internal policy on the protection of personal information. And the benefit of having an internal policy on the protection of personal information is that you will enable employees to be guided, and in the event there is any confusion as to what processes to adopt or to follow, it will provide the clarity and the guidance that's needed in your operating environment. So the policy would have to guide your organization and employees on how they ought to be processing personal information as aligned with the conditions of lawful processing. And some of the recommended, and this is not an exhaustive list, some of the recommended policies and strategies you can adopt is, firstly, ensuring that you develop a personal information strategy. Integrate how the protection of personal information, integrate that with your risk assessments and your risk reporting, because compromised personal information is a huge risk in all environments. Develop a protection of personal information charter. Include the protection of personal information in your mission, your values, and the culture of your organization. Ensure that you can get employees to acknowledge and agree to the adherence of the protection of personal information and privacy policies in writing. Conduct an annual review of this policy and incorporate principles of ethical governance of personal information. Undertake an assessment of all processing activities that are undertaken in every division. And this will be clarified when we talk about the PIA. So every processing activity in your business environment in terms of your division and your job function must be identified. Identify also in relation to those activities whether or not there is compliance with POPI, and in addition to that, try to identify what are the risks that are associated with that processing activity. Identify mitigating measures linked to each processing activity. Assign individuals to implement your records management policy, tools, and implementation plan. And categorize your different types of information being processed, whether it's personnel information, legal information, financial information, your disaster recovery information, commercial and operational information. When you develop an inventory of personal information, you'll be able to classify and categorize that information. Record every processing activity and maintain a register of each processing activity. And this actually requires you on a very granular level to think about what is processing exactly. If I am going to secure personal information from an applicant and I have a file, if I have a file of personal information on my desk, you are actually processing personal information. how do you secure that personal information aligned with POPIA is something that you're going to have to think about. The most basic task would have to be thought of and identified when developing your inventory of personal information. So if you classify information, you can also develop a retention and disposal policy in accordance with the data sets and the categories of information that you process in your environment. It will be necessary to conduct an audit again of all current processes where you collect, store, share, correct, and delete personal information. It's going to be necessary for you to identify special personal information, because special personal information will require a greater level of protection to a large extent. You need to identify again all personal information that you have processed. Identify how that information was collected and where the information was collected, stored, and processed. Identify every person that processes personal information. Maintain your register of every activity conducted and its associated processing activity, because there might be activities that would be linked to your initial processing activity, and you need to identify that. Develop a procedure that will enable a data subject to object to the processing of their personal information. We spoke about a retention policy already. Develop a policy on information quality. And the reason for this is that you need to ensure in terms of POPIA that the information that you hold is updated and accurate. And the only way you can do that is if you have a policy on ensuring that your information is updated, because it's often that you might have information that has not been verified or updated. And I mean, it's quite there are other, it seems as if it's quite lengthy, but all of these processes are quite necessary. If you also need to develop a procedure to deal with the correction and deletion of personal information in terms of Section 24 of POPIA. Develop a process where you can notify the data subject on the reason for processing the type of information that is being processed. The details of the responsible party processing the personal information, and if the necessary consent was secured. Was the personal information collected directly from the data subject? Conduct a process to map all the personal information that is being processed, and ensure that personal information mapping is reviewed on a regular basis. I think you need to also establish the lawful basis for your processing activities and a framework to establish and assess legitimate interest. Document the lawful basis for processing of personal information, and establish a register of all consents that have been secured. The review process to secure and review the process to secure consents on an annual basis. It will also be necessary for you to develop a policy on internal and external sharing of personal information, develop an information asset register that will keep a record of systems, procedures, applications that are used for the processing and storage of personal information. And I spoke about this earlier. So ensure information is accurate again. All employees must compile a monthly report on personal information that is processed. And that report should be escalated monthly to the information officer, and to ensure that the information officer is fully apprised of all processing activities. And it doesn't have to be something that's laborious or cumbersome to do. It can be a simple register that you develop. Develop a policy on how you use personal information and for that specific purpose. And if you're utilizing that information for any purpose that's beyond the purpose that you initially collected it for. And I did say that it's not an exhaustive list. So I just this slide basically, it draws on numerous global compliance and accountability frameworks, which is the same as a compliance framework in Regulation 4. So, and a data privacy compliance and accountability framework, will ensure that you have these components, which would include governance, your risk assessment process, your organizational process, a process that will also cater for your day-to-day operations, ensure that you include some sort of data security or information security practice, whether you're going to encrypt information or not, or whatever process that your CIO will recommend. Ensure that you can cater for breaches and that you can manage breaches, assess, monitor, and review the breach procedure. Look at how you engage with third parties. Conduct a due diligence. Look at your agreements with third parties. And I think importantly, look at how your HR processes are being managed internally. Make sure that you provide training on compliance. And identify any projects that you might be working on, and to assess if there's any special personal information that is being processed in those projects, and how you can ensure that you protect that information. And then again, from a legal and compliance perspective, ensure that you review contracts to make sure that there's compliance with the protection of personal information. This slide is basically a tool that would improve privacy, and it's called the Nist. It's a global framework, and basically it identifies some of the tools that you can utilize to boost information security in your environment. And you can see here it talks about a cybersecurity framework and a privacy framework. And I think the days have now gone by where you cannot include cybersecurity and privacy. They are inextricably linked. You can't deal with one without dealing with the other. And as you find through automation and the development of AI, how important it is, even from a development phase, and I say it from a design phase, issues of cybersecurity, privacy, and ethical AI. As you develop technology, these factors have to be considered from the design phase. After you have a product and you've already put that product in place, or it's too late, because it's very difficult to have aftermarket features that would include cybersecurity, privacy, and ethical factors. And my recommendation is that even when you're contracting out, when you're developing software, or you're asking for software to be developed, that your developer must be able to show you how they are abiding by cybersecurity, privacy, and ethical principles. And if they are unable to do that, I don't think you should continue, because if the development of software and development of technology that we utilize and support is not going to support principles of privacy and cybersecurity and ethical principles, I think as we move forward, we headed for disaster, and you make your environment quite vulnerable in that regard. These are the different phases that enable the protection of personal information compliance. It says data privacy here, which we in South Africa utilize the protection of personal information, but it means the same thing. It talks about assessing, designing, transformation, operation, and conforming with these principles. I'm not going to go through it any further than that. Coming to a personal information impact assessment, privacy impact assessments, or PIAs, or they are even called data protection impact assessments, they are one and the same. Global privacy frameworks require that an impact assessment has to be conducted in specific circumstances. For instance, if there's a high privacy risk project, or you have changed a business process, or there's a new way of processing personal information that could have quite an impact on the privacy of data subjects. In instances where information is profiled, where automated decisions are made, which could lead to legal implications, and it could also lead to prejudice of data subjects, where you have systematic monitoring. The difference with our process in POPI is that we don't have defined categories when you need to conduct a personal information impact assessment. It's pretty open because Regulation 4.1b doesn't prescribe the circumstances when you need to conduct a personal information impact assessment. It merely says that a personal information impact assessment must be conducted to ensure that adequate measures and standards exist in order to comply with the conditions for the lawful processing of personal information. There are certain examples of processing that can attract high risk, and those would be, for instance, processing of special personal information on a large scale, the merging or linking of personal information on incapacitated persons or those who have limited ability to act, when you are utilizing new technologies or biometric procedures, trans-border flow of personal information to countries which may not have adequate protections for data subjects, processing which would obstruct data subjects from exercising their rights. You will find that in the jurisdictions such as the EU, the UK, Australia, and Canada, they would conduct an impact assessment when there's one or more of the factors that I've discussed occur. But we, as I mentioned, POPI is silent on those qualifications, and it actually means that you can conduct a PIA when you deem, or when the information officer deems it necessary to do so. The identification, assessment, and management of risks, of privacy risks, again, is a fundamental component of accountability. You see, the principle of accountability, or the condition of accountability, features again when it comes to conducting a personal information impact assessment, similar to what we see in the need for a compliance framework. You need to understand the risks that are created by the way you process personal information. And most importantly, you need to ensure that you identify proportionate mechanisms to every risk that you identify. So the PIA is actually a risk management tool, and it will enable you to identify, record, and minimize risks to the protection of personal information. The PIA would include, for instance, the nature, scope, context, and the purposes of processing. It would also assess your necessity. I mean, is it necessary for you to process that information? Is it proportional? And you would be able to identify compliance measures. It will enable you to identify and assess risks to data subjects and identify any additional measures that would enable you to mitigate those risks. So the PIA should be able to assist you in mapping the flow of personal information between responsible parties, operators, and data subjects, and your internal systems. It will assist you to identify procedures that will diminish your ability to comply with POPI, and it will also enable you to mitigate and reduce high risks. So it's basically a process. It's a documented process, and you need to have controls that you can review periodically. Some jurisdictions conduct a personal information impact assessment or data protection impact assessment annually, or in the instances that we discussed earlier. The components of a personal information impact assessment: it would firstly identify how personal information is processed and the source of processing, who is accountable and who is responsible within the organization for processing that personal information. It would also identify the purpose that the personal information is processed, how that personal information will be processed. Again, we talk about the personal information retention and disposal policy, how personal information will be managed and modified, how personal information and processors and application developers will protect personal information. Again, it will be able to identify how personal information is processed when transferred to other jurisdictions. Thank you. That brings me to the end of me unpacking the essential components of the personal information impact assessment and the compliance framework. Thank you.
Thank you very much, Ms. Srigulal. We will now take Ms. Shilembe's presentation, and then we will combine the question and answer session after her. Ms. Shilembe is a seasoned researcher, successful at conducting notable independent research in social policy research and public policy analyses. She has over 11 years of experience with an eagerness to advance knowledge through forward-thinking investigations and experience in conducting and overseeing key strategic research projects, data collection, and insights, which have enabled organizations to make informed decisions towards policy formulation. For the past 11 years, she has used her research expertise and research findings as a voice for the most marginalized and voiceless in society, and ensure that their views form part of policymaking and are cornerstones for decision-making processes. Ms. Shilembe is currently a senior manager for policy analysis and research under Legal Policy Research and Information Technology Analysis Division at the Information Regulator South Africa. Thank you very much for sharing your time, Ms. Shilembe. Please, will you take the floor? Thank you. Ms. Shilembe? Okay, thank you.
Thank you so much, Prof, for the introduction, and also thank you to Ms. Sulal for providing that background or theoretical background on the personal information impact assessment. So what I'm going to be doing from now on, then I'll be going through the template which responsible parties or public and private bodies can utilize in order to undertake the process of personal information impact assessment. So as part of a purpose or introduction to my presentation, over and above what Ms. Sulal have alluded on in terms of the responsibilities and duties of the information officer of a public or a private body in section 55 of POPI, is that under section 111.2 of POPI, there are regulations, and one of those regulations is regulation 41B, which prescribes that information officers must ensure that a personal information impact assessment or impact assessment is will refer to it at some point during this presentation is undertaken. So an impact assessment is the process which is, I'll just unpack what is it utilized to do, as Ms. Sulal have already alluded to that, but I'll just quickly go through what is utilized for. It is to identify types of personal information processed by the entity and the manner of processing, assess compliance with the 8 conditions for the lawful processing of personal information, which are found in section 8 to section 25 of the POPI Act, and also identify risks associated with the manner that we are processing such personal information. As Ms. Sulal alluded as well, that this is one form of identifying risks which are associated with the manner in which the public body or an entity or private entity is processing personal information in its possession. And lastly, it is to then propose mitigation measures and aimed at minimizing the identified or anticipated risks. Here we're talking to measures that we maybe as an entity or as a public or private entity that can recommend in order to minimize whatever risk that would have been identified as posing a threat or to the rights of data subjects. Then I'll quickly go through the PIA components or the personal information assessment components. Over and above what have been discussed, I'll just go through all the components that will then be outlining in the template, which then explains how a personal information impact assessment needs to be undertaken. Firstly, we've got type of personal information. Type of personal information, then it is largely outlined in the POPI Act under Chapter 1, under definitions. It is outlined as relating to an identifiable living natural person, or where it is reasonable and identifiable existing juristic person. So this can range from people's race, gender, sex, pregnancy, marital status, or information relating to their education, to people's education or data subjects education, medical or financial or criminal information, or also biometric information of the person, or people's personal opinions or views. Those are all types of personal information. Or also you can also include company details, because company details are attached to a specific person. So for instance, if you reveal a person's or a company's registration number, a company belongs to a specific person. So if you punch in such a number in a specific, maybe in a specific program, it can be able to then pull out all the details of the directors of such a company. So that is also regarded as a personal information. Next component can be the manner of processing. Here then we are talking to then, and after having identified the type of personal information, all the types of personal information processed by a public or a private body, then we're talking to the manner of processing. The manner of processing as well is also quite a wide concept. It's wider than what actually meets the eye. So here we're talking to the main word here is processing, which talks to it can talk to how then we receive such information. After receiving, how do we record it? How do we store such information? Then how do we go about destroying or deleting such information after the purpose for which it was collected or processed for have been achieved or have been concluded. So another component again of the personal information impact assessment is the description of conditions for lawful processing of such personal information. Here then that's where we are going to then unpack all the 8 conditions for lawful processing of personal information. Then here it's going to be a condition, and then under each condition there are questions or shorter questions which have been summarized from the Act in order to enable public or private bodies to be able to ascertain if they are complying with each condition or not. And then the next component would be the assessment of compliance, where public and private bodies then or responsible parties would be able to ascertain their compliance. They have to specify yes or no, and if they are complying, then they'll have to then specify to motivate how they are complying under this component of PIA. And then after that, we assess risk. We call it assessment of risk. Then here we assess the risks that are associated with the manner in which we are processing such information, or the risks that are associated with either we are with our compliance with each condition. Then after that, we then propose mitigation measures, which then are aimed at minimizing whatever risk that we would have identified under the assessment of risk. So then we are moving then the assessment of the compliance of compliance and risk. So this is actually the heart of the personal information impact assessment. Firstly, I'm going to then explain the headings of the table, because they are the ones that are going to be able to guide responsible parties to be able to populate the template or populate the impact, the personal information impact assessment template, or undertake the process rather. So the first heading in the table, we've got the type of personal information, as I have explained in the previous slide, that here we are identifying all the types of personal information that responsible parties process for data subjects, which range from the age, gender, ethnic origin, pregnancy or health status, financial information of data subjects, medical information or educational information, or data subjects' personal views, and so forth, as outlined in the Act. Here in this column, that is where responsible parties have to list all those types of personal information that they process. And then the next column, the next heading in the table, it's how do you process this personal information. So for each type of personal information that would have been identified in the previous column, then you would have to responsible parties then would have to account in terms of how then do they process. As I have explained in the previous slide, that processing of personal information this is also described in Chapter 1 of the POPI Act. It talks to the collection in terms of how do we collect such personal information that we have in our possession. Do we collect it via email? Do we collect it in person, or do people hand deliver it? Or do we collect it via registers? You know, sometimes when you attend conferences or seminars, there are attendance registers where people have to fill in their names and sometimes fill in their cell phone numbers and so forth. So this is what we mean by collection under processing. And then there's also receipt. Here we're talking to then how do we receive such personal information in our possession as well. Do we receive it? Is it still received via email, or it's courier? To receive it via courier, or we receive it over a telephone call, or it's in person, or it's physical, people hand deliver such personal information. I can only imagine maybe as a public body, for instance, if we have service providers who have to submit proposals or something like that, do they hand deliver their proposals which have their personal, which contain their personal information, which can be their names, their ID numbers, their company names or company profiles, and so forth. So under receipt, this is how we then account. This is how we account for receiving, in terms of how to receive the personal information. And then we move to recording as well. Recording, how do we record such information after we have received it? Do we write it? Do we receive it? Do we record it in a spreadsheet, or do we record it maybe in a book, or do we record it via, for instance, if maybe it's a conversation between two people and people are sharing their personal opinions? Do we record it in a tape recorder? If we are taking photos, if your duties involve taking photos, or it's journalism related, do we record it? Do we record it do we take it via, do we use cameras, and so forth? And then we move to storage as well, under processing of personal information. After having recorded it, then how do we store such personal information? Do we put it in a file? Do we file it? Or do we put it do we store it in a USB, or use an external? Do we store it in a computer? If we put it in a file, for instance, is it stored in a lockable cupboard, in a lockable cabinet? And then those cabinets, is there a storage room, for instance, and how safe is the storage room? Is it locked at all times? and so forth. And then we move to the updating or modification of personal information. Then how do we then update it? If there is a need to update such personal information in our position, how do we update it? For instance, a public or a private body don't have employees, and such employees, they have their ID numbers or their marital status and so forth. And then how do they then, let's say for instance an employee gets married and then they change their surname. How do they then go about updating such personal information which the public or private body might have in their possession under their name? How do we go about it? Do we have to fill in a form in order to update such information, or they can send an email? How does the entire process evolve? And then under distraction, then after maybe a purpose for such personal information have been achieved, or beyond the purpose of such personal information for the purpose for which it was collected for, how does then the company or the private or public body go about distracting or deleting such personal information? Because we cannot keep personal information for a definite period while the purpose for which it was collected for have been achieved. This is what we covered in under the how to process, under processing of personal information. Then the next column talks to the description of the condition for lawful processing of personal information. Here, that's where we go deep into the conditions, the 8 conditions for lawful processing of personal information, which are found in chapter from section 8 to section 25 of the POPI Act. There are 8. And then in this template, then we have we have a condition, and then under each condition, we have broken them into little or shorter questions, which are going to enable responsible parties to be able to ascertain their compliance status with each condition. So the next column talks to the assessment of compliance. That's where responsible parties then can be able to ascertain if they are complying or not, depending on the question which is being posed under each condition. The second last column talks to the assessment of risk to data subjects. Here we're talking to potential harm to the rights of data subjects, to the rights and freedoms of data subjects associated with the manner in which we are processing personal information, whether we are complying or not. What are the associated risks to data subjects? How is the manner in which we are processing, or in the manner in which we are complying or not complying with the condition, then pose a harm to the rights of and freedoms of data subjects for which we possess personal information for. And the last column talks to the mitigation measures and conclusion. Here, then that's where we propose then mitigation measures or systems which should be put in place in order to minimize the identified risk, the risk that we would have identified in the previous column, such as maybe if we say we are not complying with condition 1, then what should we put in place in order for us as a responsible party to be able to comply and also ensure that we are lawfully processing personal information of data subjects that we have in our possession. So from here, then after explaining each heading in the table that in the template that we are using for the personal information impact assessment, that's when then we go to each and deeper into each condition, which are and all the conditions that are outlined from section 8 to section 25 of the POPI Act. The first condition, it talks to accountability, which is found in section 8 of the POPI Act. Under accountability, then there's a question there that says, are there measures in place in order to ensure compliance with the conditions for lawful processing of personal information? So by measures in place, we are referring to data protection policies. It can be records management policy, data protection policies, breach management policies or access to information policy, documentation of processing activities, implementation of appropriate security measures. So under this condition, I'm just going to make one example under this condition of accountability. So in terms of how then responsible parties can go about populating the entire template. For instance, these questions that says, are there measures in place in order to ensure compliance with the conditions for lawful processing of personal information? Then the next column says assessment of compliance. Are there measures in place? So say that's where the responsible parties then have to indicate if there are measures in place or no. So that's where you say yes or no, depending if there are such measures in place that I have outlined, such as data protection policies, breach management policies, and so forth is outlined here. That's where you then ascertain. Even if you say yes, there are measures in place, you have to name them all under this column. And then the next column says assessment of risk to data subjects. So here, that's where we identify risks that are associated to how we have answered in the previous column. Assessment of risks, which are potential harms to the rights of data, to the rights and freedoms of data subjects. This way, then we identify risks. If there are no measures in place, what are the potential risks that could be identified as posing harm to the rights and freedoms of data subjects for us not complying, for not having measures in place which ensure that we are lawful, we are adhering to the condition, to the 8 conditions for lawful processing of personal information, and then we propose mitigation measures. And then we move then to condition 2, which is found in section 9, from section 9 to section 12 of POPI. It talks to processing limitations. So in essence, it looks to lawfulness of processing, minimality, consent, justification, and objection, and collection directly from data subjects. So in essence, under lawfulness of processing, the question there that is posed under that is the personal information processed lawfully in a reasonable manner that does not infringe the privacy of a data subject. So here we are referring to in the manner in which we are processing in the manner in which you as responsible parties are processing personal information in your possession. Is it lawfully? So by lawfully, we are referring to are you adhering to all the 8 conditions for processing of lawful or processing of personal information? And is it in a reasonable manner, in a sense that is it fair, practical, and sensible? So in a sense that it doesn't infringe the privacy of data subjects. So, and then you do the same as I have outlined in the previous slide. In terms of compliance, you answer the question if you are complying or not, and then identify risks that are associated with the answer provided in the previous column, and also then propose mitigation measures in order to minimize the identified risk. And the next is minimality, still under the same condition. Minimality is the personal information being processed adequate, relevant, and not excessive. For instance, here we're asking if personal information that you have in your possession as a responsible party, is it only the personal information that you actually need to have and need to process? And for instance, if I'll use an example of the attendance register again. If you are collecting personal information via the attendance register, for instance, and maybe you just want to see who attended or how many people attended and actually who attended from which organization, but then you still ask people maybe to provide their cell phone numbers and email addresses as well, while we are not actually going to use such personal information. We are not going to process it for any further, but then we are still collecting it. So that somehow would incorporate excessive processing of personal information, and sometimes it to be irrelevant because it's not personal information that you are going to use, but you are processing it, but then we do not really need to process it at that time, because collecting itself is processing of personal information. And then you also then have to ascertain your compliance status and the risk associated with your compliance status, and then propose mitigation measures. And then still under the same condition, it talks to consent, justification, and objection. Here we're talking to permission or that is provided by data subjects for you as a responsible party to actually process their personal information in your possession. The question here is, does the responsible party applicant obtain consent from data subject when processing personal information? So here we're asking if when processing data subject personal information, do data subject give permission willingly to you as a responsible party to process their personal information? Do they give you permission? Do they really understand? Is such a permission given? Do they understand? Is it such consent? Is it informed in a sense that do they understand that what you mean by processing of their personal information and what you are going to go about it before they can even give you consent or approval for you to process their personal information? Another question under consent is that are there mechanisms in place for data subjects to provide consent for their information to be collected? Here we are talking to mechanisms such as consent form that can be developed by a responsible party in order to ensure that data subjects really do give permission or approval for their personal information to be processed by the responsible party. So even if it's orally, then it must be recorded so that it can be documented accordingly. And the next question under the same condition is collection directly from data subjects. Here we're asking if the personal information collected, is it collected directly from data subject except otherwise provided for in section 12.2 of POPI. So we all know that personal information have to be collected directly from data subjects for it to be processed so that they can be the ones who give consent that their personal information can be processed. However, there are exceptions that are provided in section 12.2 of POPI in instances where personal information does not have to be collected directly from data subjects, such as if it's personal information pertaining to children, and also if such personal information have been readily made available in the public domain by the data subjects themselves. So in those instances and others outlined in section 12.2 of POPI, where responsible parties do not have to collect information directly from data subjects. The third condition is the people's specification, which is in section 12 and 14. Under people's specification, we're covering collection for the specific purpose and retention and restriction of record. Is the purpose for collection explicitly defined to data subjects? When we collecting or processing personal information of data subjects, do we then, as responsible parties, explicitly define or explain to data subjects that the purpose behind our processing activities for their personal information? Under retention and restriction of records, is there a framework or policy which guides to ensure that data is not kept or retained for any longer than is necessary for achieving the purpose for which the information was collected? So because then each personal information processed or collected is processed for a specific purpose, do we have then a framework or policy in place which guides to ensure that once the purpose of collection or of processing have been achieved, then is there a policy which ensures that such information of such personal information is not kept or retained longer than it's necessary after the purpose have been achieved? And are there guidelines in terms of how personal information is altered, updated, destroyed, or deleted? Do we have guidelines or a policy in place which then informs in terms of how does a department or organization goes about altering, updating, or destroying personal information after the purpose have been achieved? Condition 4, which talks to further processing limitation, which is in section 15, talks to further processing it must be compatible with the purpose of collection. The question that we have there is that do we have systems in place to ensure that further processing of personal information is in accordance with the purpose for which it was collected? So under this condition, we are looking at if, for instance, if a certain company collects, you have your phone numbers, you give them your telephone number. For instance, an insurance company, they'll have your telephone number. If you want to take a certain policy from an insurance company, they'll have your telephone number so that they can contact you in underwriting you for a certain policy. But then you'll find that after that, you find other insurance companies now contacting you regarding a policy which is almost in the same nature with what you have inquired from company number one. That is now further processing of your personal information, and it is not allowed as far as POPI is concerned, because then now the purpose is beyond what you initially gave your numbers for. You gave your numbers to a specific company so that they can underwrite you for a specific policy in that company. So if now it is used for the next company still underwriting you for a policy, but then it did not initially give or consent to giving you numbers to that second company, which is now contacting you about a policy. So condition 5 talks to information quality, is in section 16. Are measures in place to ensure that personal information collected is complete and accurate. You know, sometimes we have, we're talking to verification measures to know that to verify personal information, which is in our possession. I'll just make an example here. If, for instance, if we have personal information under my name as Ms. Shelembe, you have my probably my cell phone number, and probably a medical practitioner. So I have consulted you as a patient, and you have my numbers. You need to contact me regarding certain health conditions. You need to provide me with feedback, or maybe I've taken tests or something like that, and maybe you have my email address, then you email that to me, but then you do not have a verification measures in order to ensure that the email address that you have under my name really belongs to me, it's correct, it belongs to me, and it's accurate, and you happen to share such my health information in under that same email address, which was not verified, only to find out it was not, my email address was not captured correctly. So you would have then shared my personal information with the wrong data subject, and it would have gotten to the wrong hands, which is why then it is necessary that organizations or public and private bodies do have measures in place to ensure that personal information that they have is complete and accurate. It's just one of the reasons why it's important to have such verification measures in place. Condition number 6, which talks to openness, is in section 17 and 18. It talks to openness of a responsible party to data subjects of which they personal information they are processing. Here we're talking to notification of data subject when collecting personal information to inform data subject that their personal information is being processed, such as collected, used, stored, distributed, or distracted. You actually have to inform data subjects, so you have to answer here if you inform them or no. And then another question is, do you inform the data subject of the possible use of their personal information by third parties? If so, under what circumstances? So under this question here, we are asking if you have data such as personal information and you happen to share it with a third party, to inform them that you might share their personal information in your possession with the third party. Condition 7, which talks to security safeguards, from section 19 to section 22 of POPI. It talks to security measures on integrity and confidentiality of personal information. Are the appropriate measures in place to ensure that integrity and confidentiality of personal information is secured? Do we have appropriate measures in place? If we keep people's personal information on the laptops or desktops, do we have strong passwords which will ensure that outside parties or unauthorized parties do not gain access to such personal information? If we keep personal information in a file, where these files kept, are they kept in the lockable cupboards? Are they kept in the storage in order to ensure that unauthorized parties don't gain access to such information? Have regular verifications been conducted to assess if safeguards are effectively implemented? Have we as responsible parties, have you conducted the regular verifications in order to assess if such safeguards that you have in place are effectively implemented? For instance, if you say employees, probably employees from HR, they have other employees' personal information in their laptop, and the safeguard that you have is that they have strong passwords which are not easily accessed by unauthorized parties. Have you done regular verifications in order to really assess if such safeguards are effectively implemented to such employees from your HR component? Do they effectively use such passwords? Do they really ensure that their laptops are always logged at all times? Do you really update safeguard mechanisms? Do you continually update safeguard mechanisms in place to new risks and deficiencies? Do you then have to update such safeguard mechanisms in response to new risks that would have been identified? The next question is, under the notification of security compromises, are there procedures in place to inform the information office of a notifiable breach or personal security compromise? In case there's a data breach that happens in your department or within the company or the organization, do employees know what they need to do in order to report such a breach to the information officer of the organization or of the department? Because in terms of the POPI Act, Section 22 does say that such a breach needs to be reported to the information regulator. But before it comes to the information regulator, employees within a company, within an organization or a department, they need to then know what steps do they need to take as far as informing or reporting such a breach to the information officer of a department or of a company. Condition 8, which is the last condition, is data subject participation, which is from section 23 to section 25 of POPI. It talks to access to personal information. Data subject access to personal information. Is there a system in place to grant data subject easy access to their personal information that you might have in your possession? And then correction of personal information. Are there procedures in place to correct or delete personal information about data subject that is inaccurate, irrelevant, excessive, out of date, incomplete, misleading, or obtained unlawfully? So with all these conditions, then responsible parties have to follow the same procedure in terms of compliance, indicate if they are complying or not, and provide motivation if they are complying, what is in place that proves that they are complying, and then identify risks which could be potential harm or risk to the rights of data subjects, and also propose a mitigation measure for each risk that will have been identified under each condition. Thank you. That is the end of my presentation as far as the personal information impact assessment template is concerned. Thank you.
Thank you very much to both Ms. Sulal and Ms. Shilembe. We have gained very valuable insights today regarding the PIA and the various components with accountability and protection of information. The National School is definitely pursuing training in this regard, and we really thank you for the insights. I'd now like to open the floor to questions. There are 3 raised hands. Can we take the first question from Ms. Masabata Maketa? Please, can we enable the mic for Ms. Masabata Maketa? Please go ahead. Ms. Masabata? would you like to go ahead, please? Okay, I think we might be having some technical issues. Can we please request you to raise your question in the Q&A box? Ms. Babalwa Badlani, if we could take your question, please. Could we please enable her mic? Ms. Babalwa, could you please share your question?
We have enabled her to talk. She can talk now.
Okay, I think perhaps she may have just stepped away for a moment. Ms. Sohana Radnath, would you like to perhaps go ahead, ma'am?
Sure, thank you so much. And thank you for the presentation. It was most insightful. I really appreciate both presentations. It's a question that we're currently dealing with right now within our organization. We're doing routine internal audits, compliance risk management, monitoring sessions where we, in order to test the company's compliance with regulatory requirements and with general governance requirements, we need to do certain audits and monitoring, which from an evidentiary perspective would sometimes contain personal information or information that is personal in nature. ARTO being one example where we need to receive driver's license, or triple BE audit where samples are done. We need to find out, do we really need consent? How do we deal with this within the organization, where in order to do and to have good governance, we need to implement a robust compliance risk management program. And within that program, we need to request information that is personal in nature. However, it is not required in terms of any specific piece of legislation that we do these monitoring and auditing. How do we deal with it, especially from a pure auditing, monitoring perspective, routinely across the organization, that needs to be done to ensure compliance and good governance? Thank you.
Thank you very much for your question, ma'am. May I direct the question to any of the panelists? Please feel free to enable your mic.
Hi, it's Varsha. I think I'll just take that. I think for you, if you don't have a statutory obligation and there aren't any exemptions that are applicable to you, when you are processing personal information, you're going to have to ensure that you secure consent for the personal information that you are processing. I think that's one of the critical issues that you're going to have to undertake. And I think it's also going to be necessary for you in terms of your compliance framework that you're looking at is going to be like your enterprise-wide compliance framework that you would deal with other issues. But I don't think it's going to be remiss of you to ensure that you have a compliance framework that ensures the protection of personal information, because you can easily dovetail those two processes. They don't have to be divorced from each other. You can ensure that the imperatives that you capture in your compliance framework are included in your wider compliance for your organization. So they don't, it doesn't have to be a cumbersome process. I think firstly, you have to be able to classify that information that you have. Classify it, identify it, and look at how you can secure it. And in terms of POPI, what is the purpose of the collection, and how are you utilizing that information? And is it necessary for you to secure consent to process that personal information. You're going to have to, it's a difficult question because how, processing activities vary and the purpose for your processing is going to vary. And that has to be understood within your own business environment. And I don't know if any of my colleagues want to weigh in on that as well. Thanks.
I'd like to invite the panel, perhaps if you want to also comment. No further comments. I think in the absence of further comments regarding that question, I'd like to allow Mr. Julian Kruger to ask his question.
Good afternoon. I also find the session very insightful. I just want to find out, when we deal with archival records received from various organs of state coming to our department as the responsible institution, there are a lot of documents coming from the courts, and we need obviously the informed consent, because some of those documents contain information, personal information requested by other third parties. How do you suggest we deal with those type of records which come from various departmental institutions? Thank you.
Yeah, sure. Because I'm just trying to ascertain whether the processing is occurring, for instance, under one of the exclusions, because in terms of section 61C, if you are processing personal information by or on behalf of a public body, then the exclusions would apply. And is it going to be in relation to a public function? Because if in terms of section 38(1), personal information that's processed for the purpose of discharging a relevant function is exempt from sections 11.3, 11.4, 12, 15, and 18. And in any case, to the extent that where the application of those provisions of personal information would be likely to prejudice the proper discharge of the function. So I think you're going to have to ascertain what is a relevant function for the purposes of section 38(1). Is it a function of a public body, or is your function conferred in terms of the law, and it's performed with the view to protecting members of the public against whether it's financial loss or dishonesty. And I think most importantly, you're going to have to just try to ascertain in terms of which piece of legislation are you actually processing that personal information. And you've got to consider also the provisions of section 3.2 of POPI, because POPI applies to the exclusion of any provision or any other legislation that regulates the personal of information. And if that regulation is materially inconsistent with POPI, then POPI basically what it means is that if POPI provides more extensive protection, then POPI would prevail in that instance. Thanks.
Thank you very much. There's another question by Shalili Amissa. Please go ahead.
Thank you very much. And I must also appreciate the presentations made thus far. It has been indeed very informative. I come from an institution where we're going to have to publish results very soon. And we usually do it via the newspaper. And we have unique identifiers. In other words, each person whose results are going to be published has a number. And we would like to know whether we need consent to then go ahead and publish that information, given the fact that they have a unique identifier and they will remain anonymous. I mean, that number would be only known to the person to whom it applies. Will consent be required in that instance? Thank you. And
Shalili, or did you want to continue your question?
Hello.
Yes, we can hear you. Were you continuing your question?
I wanted to add that it is part of our legislative mandate to release such results.
Okay,
Thanks.
thank you very much.
Thanks. I'll just take that. I think I spoke about it. When you are processing personal information for the purpose of discharging a relevant function, and if your relevant function is couched within the legislation, then then the provision under Section 38 will be applicable to you in terms of your exemptions of certain functions. So there's not going to be a need for you to get specific consent in that regard, as you will be discharging a function of a public body. And if that function has been conferred in terms of a piece of legislation, and you need to, I'm not going to give you a blanket. I don't know what legislation that, I mean, I haven't looked at the legislation that where your results are enabled to be published publicly. But I think what you need to assess the function of you're obviously from a public entity, so assess the function and establish whether or not the publication of that information is in terms of your legislation. And if it is, then Section 38 would be applicable to you. Thanks.
Thank you very much, Ms. Sulal. I think from the question and answer board, there is a question around what is the process to follow to request data information belonging to a public body? Could I request perhaps someone from the panel to respond? What is the process to follow to request data information belonging to a public body?
I don't know if Ms. Chili wants to take that. Oh, okay. Go for it, Mr. Buthelezi, go.
Okay. The process is outlined in terms of Section 18 of POPI. So basically, there should be a request form that must be completed and submitted to the relevant public body. Thank you.
Thank you very much. And then there was another comment about a method for PIA, which is on the Q&A, and people are welcome to download from there. May I invite the panel to perhaps just share some insights with regards to the theme of the session, perhaps Ms. Chili or anybody else?
I'm sorry, you said this theme of?
With regard to the theme of the session. So if you would like to share your insights.
Sure. I think we had scheduled Mr. Dimba to wrap up, but if he's not, I'm just looking at him, he's not unmuting his mic, so.
He will indeed, but it's just to perhaps just get some additional voices from the panelists.
Oh, sure. I mean, I think one of the things is that we've thrown a lot of information at you, and I'm guessing that you're looking at it all and thinking, oh, this is just this is going to be such a thing, and we're going to have to fill in all this information and do all these reports. I think it's actually perhaps simpler than it appears. And really the main thing is that when you get people's information, you really have to think about what you're getting it for. You have to get it for a reason, and you have to need it. If you have people's information, you have to take care of it. You have to look after it, make sure that it remains accurate, that it doesn't get lost or stolen. And then when you don't need it anymore, you have to destroy it. And I think those are really the three things that you can, provided you're thinking about those things, the actual steps that are required or suggested, not necessarily required, but suggested in terms of an impact assessment, I think it will be perhaps simpler and clearer. And there may certainly be situations where some of these proposals around how to do an impact assessment may not apply to you. So I think you have to be thoughtful about approaching the framework and the impact assessment, and do it, with exercising discretion and thinking about what it is that the Act is trying to do. It's not just to tick a couple of boxes. It's really to think about your information as much as anybody else's. How would you want it treated? You don't want to get those phone calls at 6 o'clock in the evening selling you timeshare. And just as much as we're trying to protect people from that kind of direct marketing, so we're also trying to make sure that the way the state handles information is appropriate and thoughtful. So I think perhaps, I'm not sure if that will alleviate your anxieties at all, but yeah, I certainly I'm hearing that I think people are thinking that this may be burdensome, and it may require some thinking, but I hope that is useful thinking and probably necessary in the context of records management in some ways anyway. So yeah, I don't want to alarm everybody. Thank you.
Thank you very much, Ms. Chili. I'd like to now invite Mr. Dimba to please deliver the summation of the session. Thank you very much. Mr. Dimba, we can't hear you. Could you just enable your mic, please?
That should be fine, Mr. Lemmy. Your mic should be working. Oh, I think he disappeared entirely.
I think let's just give him a minute to reconnect. Apologies for the technicalities.
Shall we try that again?
Yes, thank you. We can hear you now.
Finally,
thank you very much.
My apologies for that. I had to quickly log off and then log right back in. Before I do the summation, I just want to respond, Professor Natasha, to that question that you asked. What I wanted to emphasize, it's a point that has been made previously. I wanted to emphasize the point that both the compliance framework and the personal information impact assessment initiatives cannot be separated from the organization's general risk management system. It's part and parcel of that. I hope that the presentations that were given by both Ms. Sulal and Ms. Chelembe really drove home that particular point, that this is part of the organization taking very clear, very informed actions to safeguard the information that they hold. I say this in light of what we're seeing now as a trend of data breaches, or what is referred to in POPI as security compromises. These are on the rise. These are reality for all responsible parties these days. So it's important for action to be taken to ensure that you don't fall foul of the provisions in POPI in terms of safeguarding information. And one of the principles that are very applicable in this sense is the principle of minimality. If you collect less, you create less risk. But if you collect more, then you must accept that there'll be more risk in your operations. So as you conduct the personal information impact assessment, one of the things that you really need to look at is, do you really need to collect what you're collecting right now? If you are running a training session, for example, must you really have ID numbers as part of the attendance register? So those are some of the questions that you have to look into. And again, it is important to try and minimize risk as much as possible. And it all starts by understanding what it is that you hold, how you process that information, and be clear around the levels of risk that are part of the process of processing of information. Let me just speak very, very briefly on what was presented to us today, starting with Ms. Sulal's presentation. Ms. Sulal started us off by reflecting on the obligations that are created in the law on information officers. Section 55.1 of POPI makes it very clear that information officers are responsible. They are the champions of legal processing of information within their institutions. And this means making sure that there's a compliance framework in place, it's developed and it's implemented as it should. And Regulation 4.1b creates this other obligation on production of an impact assessment within an institution. And again, these assessments are conducted to ensure that there are adequate measures and standards to comply with the conditions for lawful processing of personal information. This is where Ms. Sulal started us off. And then we looked a bit closely at the compliance framework itself and what it seeks to achieve. Some of the components that were mentioned as part of the compliance framework were things such as establishing a governance framework. It's important to have a governance framework because you don't want your compliance to rest on an individual, but there must be structures, there must be processes, there must be arrangements in place to drive compliance and implementation. And that's why you need those governance structures to be put in place. The other item that Ms. Sulal spoke quite at length about was the issue of records management. Records are the lifeblood of an information system, whether we're talking about access to information or we're talking about protection of information. They're the lifeblood of it. And Ms. Sulal took us through about 19 proposed actions to ensure that your records management practices are in good shape to enable you to comply in terms of POPI. The other component of the compliance framework I want to speak to is the idea of a policy on accessing information and the policy on information security. These are what is called soft laws. You need these soft laws which adjust what is provided for in the formal legislation and adapt it to your circumstances in your organizations. This is essentially about the rules that you develop in order to enable the institution to meet its obligation in terms of the law. You need to be able to develop those soft laws. It's a critical component. And then Ms. Sulal took us through the 5 phases of data privacy compliance. And those were essentially assessing the situation, designing the compliance framework, transforming, which basically means developing and implanting processes and procedures that enable you to comply with the legislation, and then putting those into operation. And then lastly, conforming, which is about evaluating adherence to privacy and compliance rules. So those were the main aspects that Ms. Sulal presented to us. And from Ms. Chilembe, the main takeaway for me was, again, the components that are part of your personal information impact assessment, where she presented that slide that showed the circle, basically the circle, the flow of processes when you are putting together an impact assessment, starting with identification of personal information that you hold, being clear around the manner of processing of information in each work stream or in each unit, describing the conditions for lawful processing of information for each item of personal information that is being processed, coming up with an assessment of whether you comply, as it were, in your existing systems for processing information. She also mentioned the idea of being clear around the risks. You need to assess the risks and mitigation measures. Once you are clear around the risk, what measures are you taking to ensure that risk is minimized? So those were the main components of that system that Ms. Chilembe presented to us earlier today. I think, Prof, for me, those were the key aspects that came quite clear and vividly through the presentations of the two colleagues. Thank you very much, Prof.
Thank you very much, Mr. Dimba. I really appreciate the summation and the highlighting of the key points from each presentation. I'd now like to hand over to the principal of the school, Professor Nqaweni, to provide the closure.
Colleagues, I must thank you for this empowering session today. I do sincerely hope that all the people who attended have learned a great deal from this engagement. As I indicated earlier on, my prediction is that the personal injury lawyers who were active at RAF and they moved to the Department of Health will now move across the state to try and make money from POPI violations. It's a logical thing to do. They are always looking for low-hanging fruits. As negligent as sometimes we can be, they will actually be able to profit by suing organs of state for POPI violation. More so now with the intensification of cyber crimes, which are becoming more and more prevalent in light of us migrating our work and using cloud-based solutions and so on. As we do this, we migrate and move to be heavily reliant on technology, thus increases the risk of cyber crimes. And as cyber crimes increase, the risk of us losing or compromising protected personal information also rises. Having conversations like these ones is empowering. You may not have to go to a 12-month training course to learn about how to become POPI compliant. Conversations like these ones, we take 2 hours of a valuable time. We increase your awareness, we teach you about the tools, but most importantly also, we help you network with relevant organs of state like the information regulator. If any of you colleagues have got further information to ask, if you are unclear about anything, if you need to have a bigger session in your department or institution with the information regulator, these colleagues are available. The idea of educating and raising awareness is so that we can prevent and manage risks before they become reality. We are grateful, therefore, that you responded positively to this call and the last 2 calls that we've made. We're also grateful that the information regulator acceded to our proposal and our request that they become available for such engagement. We're doing the same with the Auditor General. We're doing the same with numerous other organs of state as well, because our view as a National School of Government is the more we expose, the more we share, the more we advocate, the more we open up learning opportunities, we will build a state that is capable, ethical, and also developmental. This very intervention today is developmental because it is not punitive. It's about sharing and empowering instead of the information regulator or any other organs of state taking drastic punitive measures before we can spread the word and make all of us compliant, whilst understanding that we can be as creative as we can be under the circumstances. So we appreciate your time and your presence today to everybody. If I may request the colleagues from the regulator or those who were actually panelists today, everybody was panelists who spoke. If you can turn on your video cameras so that we can see all of you again and say officially, good afternoon to you all. So if you can all turn on your videos. Yes, we see you, Natasha, Vasha, Shengiwe, Siabonga, we don't see you. We want to see everybody who was participating today. Hello, thank you very much. It's good to have you all here. I suppose some of you may not have cameras, but we just wish to send a word of appreciation. The departments do have access to you, from now on, or any other agents or organ that was here. The most significant part about this is that all of us have learned that we have an obligation to protect sensitive personal information so that we don't go through the harassment that we go through now, all because people have been able to access and harvest their data. Today is my last day actually as a deputy chairperson of council of the University of South Africa, where we have been going through major challenges like these ones with people who've been stealing and harvesting information of students, and they monetize it through various means, thus putting the university at risk. This can happen to everybody, any of us, regardless of where we are. You could be a journalist today, tomorrow you could find yourself in court with people who make an argument that you've compromised their personal information. You could be a middle-aged officer, you think you were doing a great job for your boss who wanted to trend on social media. Tomorrow you may find yourself in court and you could be sued because there was a violation of privacy and so on. So thank you very much once again. We appreciate this. May you all have a great few weeks and a month that remain to the end of this financial year. Please be safe. Hope to see you soon in these platforms in the new year. Thank you and goodbye.
Thank you so much, Bob.
Bye. Bye. Thank you, colleagues. Bye-bye.